We can go.
Okay.
Hello, everybody. I think Joe's just told us that we're live. So firstly, thank you very much for coming and coming to our webinar. If I look a bit startled, it's because the first time I've done this one for a long time, so forgive me. Some of you, we notice we've got quite a few people, and some of you may well be gluttons for punishment because Luke Harris talked about this case at our recent art afternoon seminar. And the reason why Eliza and I couldn't talk about it was not because we think it's a boring case, in fact, quite the opposite. It's because permission to appeal at that stage hadn't been heard and it's now been refused. So we can now give you our full thoughts on it for what it's worth. We think this is a very interesting case. And for a number of reasons. First, it's got very interesting facts, as these cases often do. Secondly, it's really the first case about the duties of a consignment dealer, which has hit the courts. And it may be that they're subtly different from auction house obligations. It may be that they're not, something I'm going to deal with. And thirdly, it's probably the first case, it's not so important, but it's probably the first case since Thompson where the Court of Appeal has considered these kind of art type issues. So without further ado, because we've got an awful lot to say, and I apologize in advance if we bang on a bit, please turn us off. This is the bill of fare. Firstly, Eliza is going to talk about the unusual facts and the published literature and specific features of the piece, and observe that permission to appeal is going to be refused. And then I'm going to talk about the law a bit, firstly in relation to duties of a consignment dealer, which is really the interesting point in this case. And secondly, about causation and loss, which comes into two categories: first, loss of a chance, and fair wind. So without further ado, let's crack on.
Chardin was an 18th century French painter, and he was known for still lifes, like you can see one on the screen, and genre scenes which portray ordinary people doing domestic activities. And as the judge said, Chardin worked in a way which could have been calculated to inconvenience the art trade, because he painted versions of his own works. And that was often for the purpose of exhibiting them in the Salon in Paris, which is the official art exhibition of the Académie des Beaux-Arts. It was forbidden to show the same piece of work twice. And so the production of other versions of a composition, which had some changes, sidestepped this rule. Chardin also had a studio, but nothing is known for certain about how Chardin worked in that studio, but we do know many copies of his works exist. And therefore, the claimant's position at trial was there is a range of Chardin paintings. At the top end, there are paintings where the work of the studio is not apparent, and those pieces are by Chardin. At the bottom end, there are wholly studio paintings, and in between, there are works that have some input from Chardin, some from the studio, and within that, there can be a range of more or less Chardin input. And the basket of wild strawberries by Chardin, Panier des Fraises, was record-breaking. In 2022, whilst our case was ongoing, it was sold at auction to a New York art dealer, Adam Williams, who also featured in our case. And it's the highest price paid at auction for an 18th century painting. The importance of the strawberries cannot be underestimated. It's an iconic piece, and it was used on the cover of an exhibition catalogue in 1979, and it's in a totally different league from our painting, and the export's been blocked by the French Ministry of Culture. I'm also going to introduce Pierre Rosenberg, who was a key feature or element in this case. As I've set out on the slide, he's very distinguished, former director of the Louvre, honorary president, and the parties agreed that he is the undisputed living authority on Chardin. And there's a focus at trial on his catalogue raisonné, and those are a comprehensive listing or index of all the works of an artist. And he wasn't a witness, but the judge commented he was as present as Banquo's guest. This is our composition, Le Bénédicité, or Saying Grace, and as you can see, it's a genre painting. And the version I've got on the screen is the prime version, given to Louis XV in 1740 by Chardin himself, now in the Louvre. so you can go and see it. And that's what our client, Mr. Dickinson, did. He went to go and see it. This is our painting. Same composition as you can see, Le Bénédicité. It was acquired in 1751 by an ancestor of Lord Weems at an auction of Thomas Major, and it remained in the Weems family until the sale in 2014. And at some point it came to hang at Gosford House, and that's the family seat of the Weems family. Now, this painting, like the prime version, is actually quite small. It's about 51 by 40 centimeters. I'll explain why that's relevant. As I said, the painting was sold at the 1751 Major sale, and that's a sale of Thomas Major, who was an artist and engraver, and a sale of his collection. And there was actually a pendant to our painting, and pendants are paintings conceived as pairs, often where there's a thematic link. And the pendant was a version of La Mère Laborieuse, or the Industrious Mother. And you can see there on the screen, they were sold as adjacent lots, lot 38, the Industrious Mother, third item down, and 39, figures saying Grace. But they were split up at this auction because Lord Egremont bought the Industrious Mother, and it was at Petworth until 1927. Moving on several centuries, in the 1990s, our client, Mr. Dickinson, was advising the 12th Earl of Weems, who's the current Earl's late father, on the extensive art collection at Gosford House. And in 1992, Rosenberg actually visited Gosford House along with the 12th Earl and Mr. Dickinson. And actually, the primary purpose of that visit was for Rosenberg to look at a painting by Poussin. But whilst Rosenberg was there, Mr. Dickinson decided to show him our painting because Mr. Dickinson thought it might have a chance. And unfortunately, Rosenberg dismissed the painting as totally studio. Now, at trial, there was an issue about whether Rosenberg could really have seen the painting properly. The claimants thought the painting was probably then hanging in the garden bedroom, which is the blue room you can see on the screen. And in cross-examination, Lord Weems was taken to that particular photo, and it was put to him by Henry that in the mirror you can see a door onto the corridor. And Lord Weems accepted that. He accepted that the picture gallery comes off these corridors and that there's lots of light in the picture gallery, and you can see the picture gallery there also on the screen. And as I've said, the painting is small and therefore portable. And Mr. Dickinson's evidence was he took it off the wall and showed it to Rosenberg in good light. And that's the natural thing to do with a picture gallery just off the same corridor. And as we'll come on to see, Rosenberg also updated his catalogue after this visit. The claimants at trial tried to argue that Mr. Dickinson's memory must have been faulty because Rosenberg couldn't possibly have said it was totally studio based on what he said in the catalogues. But the judge accepted Mr. Dickinson's evidence of that visit in 1992. Following the visit, Mr. Dickinson, first in his capacity as Christie's and then subsequently in his capacity as Dickinson & Co., which was set up in 1993, they acted for the Weems family in the sale of 4 other paintings on behalf of them or the trust. And that included a painting which Mr. Dickinson discovered was an autograph work by Botticelli when his colleagues at Christie's had been rather dismissive of it. I've mentioned the catalogues, Rosenberg's catalogues, and the first one was in 1983, and it was then updated in 1999. And by 1999, there were 204 prime originals, or compositions. And the composition Le Bénédicité is number 121 by the time we get to 1999, and it was number 120 in 1983. And if we look at the 1983 column, you can see at the top, the very first item is 120 without any letter. And that's the Louvre version, which I first showed you. And that's the one that Rosenberg considers the most beautiful on this list. 120A is another version in the Louvre, and that's a copy that Chardin and then his wife kept. 120B is our version, and you can see it's described as copie retouchée. 120C was acquired by Catherine II of Russia and is now in the Hermitage, and 120 lowercase d it's not clear if this version is a copy, hence copy ? And Rosenberg explained in his catalogue that there are variations between all of the Benedicite compositions, except ours, which is an exact copy of the prime original. And here we've got the two Louvre versions on the screen, and you can see the prime original has a tiled floor, but that's not the case in the second version. So those are sort of variations that there might be between the compositions. Going back to the catalogue, if you compare 1983 to 1999, you can see that the B, capital B, has become bold. And that means, according to the catalogue note, that Rosenberg had seen it. And that fits with what we know, which is this one visit to see the painting in 1992. And so the conditions must have been sufficient in 1992 during Rosenberg's visit, because otherwise he wouldn't have upgraded the painting in this way. And I'll come back to the catalogues because there was quite a lot of a disagreement about what they all meant. The sale of the painting does have some quite striking facts. It was sent to the Dickinson London premises in mid-May 2015, and the following day it was sent to a renowned restorer, Sarah Warden, for a light clean on Lord Weems's instructions. It was after it was cleaned that Mr. Dickinson went to the Louvre to compare it with the prime version. Then in July 2014, a Swedish dealer, Mr. Amell, and his eye, Adam Williams, inspect the painting. And one of the problems that Mr. Dickinson was facing was there was a limited range of organisations or people he could sell it to because of the attribution he considered it had, which is Chardin and Studio. And he'd been told by Vermeer Amell that he had a client looking for a Chardin. Now, there were negotiations in the gallery, and there was also at this time a fact sheet in existence which described the painting as Chardin's Studio. Although Mr. Dickinson's evidence was that as an experienced dealer, Mr. Amell would not have relied on it, and the judge accepted that. Subsequent to these negotiations, Lord Weems and Mr. Dickinson have a telephone call in which they discuss the price, although neither of them can remember almost anything about that call, but they both said it happened. The trustees approved the sale, and it was sold on the 15th of July 2014 for 1.15 million to Mr. Amell. It was then sent for a deep clean. A signature was discovered, although that's a bit of a red herring when it comes to Chardin paintings, but it was marketed as a major rediscovery and described as a fully autographed masterpiece by Chardin. So then in January 2015, it was sold to an American collector for what was apparently 10.5 million US dollars. That was made up of cash, but also a Watteau painting, and that's the Watteau painting you can see on the screen. But the parties actually agreed that the Watteau painting couldn't possibly have been worth that much, although they didn't agree on exactly how much it was worth. But at any rate, you can see it sold for much more than it was originally sold for only 6 months later. And therein lies the claim. Now, the allegations of negligence, I've set them out on the screen, but in essence, the claimants allege that Dickinson's had breached their duty of reasonable skill and care, but also their duty to obtain the best price reasonably obtainable. And in his judgment, the judge went through each of the allegations of negligence under their subheadings, which I've set out on the screen, and he finally concluded that there had been no negligence in any regard. And that all of these heads of negligence could be its own talk, but for now I'm just going to focus on two of these. The first is the decision not to consult Rosenberg, because after the light clean and after Mr. Dickinson's visit to the Louvre, Mr. Dickinson formed the firm view, which he'd had before, but it was confirmed that it was part Studio, part Chardin. And he was worried that if Rosenberg saw the painting in its clean state, given what Rosenberg had said back in 1992, the value of the painting could have been destroyed if Rosenberg had then reiterated that it was wholly Studio. The judge held that, therefore, consulting Rosenberg was a spin of the roulette wheel, and it was not negligent not to take that gamble. I'll now look at the Chardin Studio element in a bit more detail. The claimants tried to argue that Mr. Dickinson's personal belief was that it was actually by Chardin. And what they relied on is that in some informal documents, such as emails, Mr. Dickinson had referred to the painting as the Chardin or by Chardin. But the court accepted his and his colleagues' evidence that this was just an informal way of speaking in informal documents, and it was just shorthand for Chardin and Studio rather than typing that out in full every time. And the court commented that Mr. Dickinson's evidence was clear. Having gone to the Louvre, seeing the painting, our painting, in its clean state, Mr. Dickinson thought that the brazier that you can see in the bottom there and the child's dress were authentic Chardin, whereas the composition, the background, the faces, and the woman's hands were very weak. And actually, I think you can see, we wrote in our closing that the woman's hand has a sort of club foot element to it, which it doesn't in the prime original. And the court held that at all material times, Mr. Dickinson personally believed that the painting was part Chardin, part Studio. The other line of attack on the Chardin and Studio was to do with the published literature, and that's one of the unusual features of the case, how much it is about the literature and perhaps less so about the painting. And I've set out the allegation from the amended particulars of claim on the slide there. It said that the defendant was hasty and careless in its reading of the published literature, and there are 2 points they're saying. They're saying that copie retouchée par Chardin, that phrase that I showed you, means that it's by Chardin alone or Chardin autograph. And they're also saying that the capital B, rather than a lowercase b, also indicates it's by Chardin. And if you remember, I'll show you on the slide, you can see a little d compared to the capital letters for the others. Now, a lot of research was done into the phrase copie retouchée and a lot of disagreement between the parties. Our position was that Rosenberg meant a copy by someone in Chardin's studio that was then retouched by Chardin himself. So you have Studio and Chardin. And unsurprisingly, the claimant's approach was that it was a copy by Chardin, a copy perhaps of another work, and then he had reworked it himself. So it's all Chardin, but he does it and he does it again. Now, our solicitors wrote to Rosenberg to ask him what he meant and explained that this was an issue. And he gave quite a French reply. And he said that he had borrowed the phrase from an 18th century catalogue and he hadn't been able to find a definition, which is why he uses the quotation marks that you can see there in the catalogue. So in a way, he's saying that he can't be sure about what he means. And in terms of this catalogue, that's not our catalogue. I showed you our catalogue. We think it was a catalogue from 1745 with one log by Chardin described in this way. And it was a phrase then that Rosenberg borrowed to describe several other Chardin paintings. And actually, and perhaps sadly, the judge didn't make a finding on that because he didn't need to after all that work on copie retouchée. So I'm just going to go back a slide to the catalogue. There we go. The other point, though, on which there was a finding and we won, was the meaning of this capital letter. And Rosenberg explains in his guide to the catalogue that the capital letters are for paintings that are de la main de Chardin, or from the hand of Chardin. So there was a dispute about what that meant. And we said, well, if you look at the catalogue, you can see that Rosenberg uses capital letters for paintings that are not wholly Chardin. For example, there was a blind beggar where Rosenberg expressly said only the beggar itself comes from Chardin and the rest is not Chardin. And the judge agreed with our analysis of the catalogue and held that in Rosenberg's estimation, there's no bright line between wholly autograph and partially autograph. And that Rosenberg uses his critical judgment to decide which of the paintings are of sufficient quality to be regarded as de la main de Chardin and attributes them accordingly. And so the judge rejected the argument based on the capital letter, and he said that can't stand. So the whole focus was on the published literature, and on that we won. And that's perhaps a flavour of how much focus there was at trial on the published material. And I just want to quickly compare that to Thwaites. That's the card shops then, that's not the actual painting in the case, but it's that's an authentic Caravaggio, an autographed Caravaggio, but the painting in the case was of the same scene with the figures roughly in the same position. And in that case, the claimant had actually pleaded features of the painting, such as Caravaggio features and non-copy features, such as the execution of brushstrokes and so on. So you can see the contrast between that case and our case in terms of whether it's about the published literature or the features of the painting. And very briefly, permission to appeal. Interestingly, there was a 3-panel just for permission to appeal, and that was refused. Ground 1, a duty and contract. The claimants tried to say that the judge had put insufficient focus on the terms of the mandate, but as the Lady Justice said, it was a case about negligence, and a breach of a contractual term simply wasn't pleaded, and we would have run the case differently if it had been. So that was refused. Grounds 2 to 6 were to do with the duty to warn, because if you remember, all that there was this telephone conversation about the price between Mr. Dickinson and Lord Weems. And so they were saying it was a breach of the duty to advise. And although the judges said initially that this was arguable, the problem was that the appeal would be academic, because the trustees would have followed Mr. Dickinson's advice based on the findings. So it wouldn't have changed the ultimate result. There was also ground 7, loss of a fair wind, which Henry's going to speak about, that principle, but that was refused as well because breach of duty was dismissed. So over to you, Henry.
Well, Eliza, thank you very much. I have to say, just seeing the card shots gave me a bit of a turn. I don't think either of us are going to be having a picture of a Betty Cité in our kitchens anytime soon. We spent too much time looking at it. Anyway, before I get onto the law, which there's quite a lot to say about, and forgive me if there's quite a lot there, but I couldn't resist just dealing with this one little point. One of the conundrums in this case was why Michel David Weil, who was a very, very experienced collector, why Michel David Weil was willing to pay $7.5 million at least for the painting, in circumstances where that was a record price at the time for Chardin, and Rosenberg had said it was a copyright touché. And many of you who might have done art cases will know that actually the reason for the high sale price is often the key to the case. There were lots of features of this sale which made it rather peculiar, and you can look at the judgment. I'm not going to deal with them now. The most interesting one was that the salesman, Adam Williams, got a very, very large commission for it. But I was just looking through a book on Vuillard the other day. For some reasons, I've got quite interested in Vuillard, and I came across this picture. And this is a picture of David Weil, who is Michel David Weil's grandfather. We could have 25 minutes on him on his own. He was a very eminent French banker in the 20s, half Jewish, half American as well, and he had an extraordinary collection. 2,000 pieces of which were sieged by the Nazis in Vichy France during the war, but some pieces were not. And this is a picture by Vuillard, who's a very interesting artist. And you just see behind him, there are 3 pictures. Now, all these pictures are Chardin, and it's possible to identify with certainty 2 of them. The other one, I'm pretty sure it's right, this as well. So let's see what they are. This one, the one above his head, is a picture called The Boy Blowing Bubbles, which you'll find in the Met in New York, which of course is where Michel David Weil lived. It's the prime version. It's one of the best Chardins, basically. And interestingly, it was bought in 1949 by the Met from Wildenstein's. And there's been a furore about its provenance because there was an intervening purchaser called Mr. Mannheim, and this picture was confiscated by the Nazis from Mannheim in Paris in I think 1940. But Wildensteins have said that they then sold it on behalf of Mannheim after the war to the Met. So anyway, one can imagine Michel David Weill living in New York, seeing this picture which his grandfather had and which he was painted with, and really wanting a good Chardin. But it doesn't stop there, because this piece, which is in the National Gallery of Scotland, is the picture on the right of his head. Can you just see it there? And this, I think, certainly, or on the basis of what Rosenberg says, this certainly is the picture in the National Gallery of Scotland. There's only one version of this composition. In fact, it's the only flower picture that Chardin ever did, according to Rosenberg, in fact, surprisingly. And this was bought in, as I say, in 1937, shortly before the war. And then the picture on the left, can you see it there? Is this picture, which has a much better French name than an English name. In English name, it's called the kitchen maid. In French, it's called la ratisseuse, which means the peeler, which is what she's doing. I think, is it a turnip there she's doing it? And this is in the Washington. I think this must be the picture in Washington. I might be wrong, but it looks like it's the picture in Washington, which was bought by the Samuel H. Croix Foundation, which is a huge collector, American collector, in the sort of pre-war and post-war period, and was given to Washington shortly after the war. So this may give some insight into why Michel David Weill was willing to pay such a lot of money for our picture. Well, actually, to be absolutely accurate, his picture now. His picture on the basis of rather a tenuous attribution and what we said was a puff piece by the expert who was employed by Mr. Amels. Anyway, that's a sort of interesting background to it. Forgive me for that. Let's do some law now. The important thing to focus on in this case is it has really unusual facts. In fact, during the course of the permission to appeal hearing in front of the judge said, because of course one of the issues is how important the case is going to be if it goes to the Court of Appeal, and the judge held, slightly my suggestion I have to say, but he held that this was a case with very unusual facts, and that's what he says. And so the question is really, what can one take out of this case which is useful or is going to be useful for other cases? And I think there are some points, but it's going to take a little bit of miming for me to get there. There's three important points about the facts which distinguish this from the normal case. Firstly, this isn't a sleeper case. So this isn't like the Thwaites case or most of the cases that arise in this context. It's not a case where something should have been spotted to make the case better, but to make the painting better in circumstances where nobody knew anything about the painting. This painting was fully documented. Secondly, and this is a very important point, there was a substantial course of dealing between the Weemses and the Dickinsons and SED before the sale of the Chardin. And that included the sale of the Botticelli for, I think, like the figures 12 million or something, the sale of the Poussin, and a few other pictures. There were almost 20 million pounds worth of pictures that were sold, two of which had an increased attribution, which Mr. Dickinson had found out for himself. So he established effectively two very important pictures with a full attribution for the Weems. So understandably, the Weems trusted him. However, the express terms of the mandate for sale were not pleaded. And this is a point that came out on appeal with much more force than it had during the course of the trial. The mandate wasn't pleaded. And I think there was good reason for that, which is that the relationship between the Weemses and Dickinson was very informal. And for Richard Edwards and Andrew Onslow to have pleaded exactly what the terms of the mandate had done would have been quite risky when they first put together, when the pleading was first put together. I don't know whether I would have done it. I think I probably would have done it now, but at the time, would I have done it? I don't know. Third point, it wasn't, and this is very important, it wasn't suggested by the Weems that the painting would have been retained if the correct advice had been given. So in practice, that meant that the Weemses had to say that the painting would have been sold for a better price at that time. They couldn't say they would have waited until Rosenberg had died or something like that, which is quite a common type of plea that you get in this kind of situation. They had to put it that way. Now, I think, again, there was probably a good reason why that was done, because the other side would not have wanted us to be going into Lord Weems's financial position, which is where we would have ended up if that point had been run. So those are the three important points. The three important findings: firstly, that no advice on attribution was given by Dickinson other than probably a Chardin. That must be very unusual. Secondly, equally unusually, the Weemses left Dickinson just to get on with finding a buyer for the painting, and they weren't concerned with the mechanics of selling. In fact, the judge's comments on the claimant's expert evidence was that it was more directed to what you would do to make sure that you didn't get sued, rather than what you would actually do for a client. Whereas Mr. Dickinson just went on and got on and did it. And thirdly, critically, it wasn't contested that the price that was achieved was a good price for a Chardin studio painting. In fact, the claimant's experts simply didn't engage with that point. So in that context, the conclusions that you can draw from as to the law that's applicable arising in a normal context of precedent. So looking at the facts and the law as applied to them, what can you take for other cases? It's almost certainly going to be quite limited, because these are very unusual facts. However, I think there are 3 points that we can look at, and all of which I think have got some importance to them. The first point is the question of the relationship between the attribution of the piece and the advice that is given to the client in relation to sale. The second point is this point about whether the consignment dealer has a duty to advise that they might be wrong in their attribution, which we actually spent a lot of time on during the course of the trial. And the third point, which actually is probably the most important point, is when will a sale by a consignment dealer to another dealer be negligent? So let me just crack on with all of these points. In relation to attribution of the piece and the advice in relation to sale, the starting point, certainly for the purposes of this argument on the current law, and certainly at the time of the claim, was the duty of the attributor arising from the Thompson cases as amended by Thwaites. And anyone that has ever been to a Feilding building seminar will probably have heard me talk bang on about this before, but this is where the law is. And the tests are, firstly, you need an appropriately qualified person and for the job in hand, taking an appropriate amount of time and care in the process of attribution. You notice how unspecific I'm going to be. And that includes the assessment of literature in this situation. And the important point is non-fanciful doubts must be shared if either A, the attributor in fact had those doubts, which is in fact the case that the Weemses were running in our case, or the attributor ought to have had those doubts. And this formulation of the duty was very important for the purpose of the permission to appeal application in front of the Court of Appeal. And you will see that the Court of Appeal in practice accepted my submission as to what the test is. So we now know where we are. And one might ask oneself is, and this of course, this test of course derives from auction houses, but if this isn't the test for consignment dealers in relation to attribution, what could it be? I mean, it must look very, very like this. It's a question as to whether each of the steps looks slightly different or applied slightly different way for a consignment dealer, for an auction house. So what I'm going to do is go through each of those steps very quickly and talk about how they relate to our particular case. Firstly, is the attributor competent? Now, it's going to depend on the job in hand. And one of the important points that we made, and which was accepted by the court, was that in Weems, the relevant job was not making a full attribution of the painting, in a sense, Mr. Dickinson, although he said thought he had a better eye than Mr. Rosenberg, that may well be right, actually. But the point was not whether Mr. Dickinson was the world expert on Chardin. The point was whether he was capable of gauging whether there was anything in the painting after the clean which made it worth showing the painting to Rosenberg again, because Rosenberg had already seen this picture. And it was effectively accepted by the other side that as a highly competent generalist, he would be able to make that assessment. That won't be the case in all cases. Secondly, taking an appropriate amount of time. Again, that depends on the job in hand. As I say, but normally for a painting which is already catalogued, that's going to involve at least proper inspection and a serious analysis of the literature. The question which does occur to me is the test going to be how much time a dealer would have applied to this attribution? Because characteristically, this is going to be a lot longer than the time that an auction house will take, particularly if they own the piece. Sorry, particularly the dealer owns the piece, that's what I mean. But that's an unanswered question, and the point wasn't put in that way in the Weems case. And thirdly, in the context of non-fanciful doubts, in the context of a catalogue piece, it's been important to remember that these are not non-fanciful doubts about the attribution which is being applied. They're really non-fanciful doubts as to whether the literature is wrong. So the non-fanciful doubts are going to work this way. This is what the literature says. Have I got reason to doubt it? And the way you're going to apply yourself to that question is by inspecting the piece and also by analysing the picture, analysing the literature, forgive me. And in Weems, it was found that Mr. Dickinson believed that the painting was by Chardin's studio. This was consistent with the literature. Both of those points were challenged, as Eliza has said, and there was no real suggestion that the painting had features which made this view wrong. Now, we made a lot of this point, that the point was never taken, that there were features of the painting which made this view wrong. But having retired from the hard melee of battle, I'm just wondering what actually the other side could have said about the painting, which would have suggested that that view was wrong. Because this isn't a case like Thwaites, where you're saying everybody thinks this picture isn't by Caravaggio, and look, at this point, this could make it by Caravaggio. The test here is everybody thinks the painting, or we say, everybody thinks the painting is by Chardin in his studio. And we admit that the elements of the painting are by Chardin. It's a question as to whether the bits that we think are by the studio actually are by Chardin. And you're really going to have to say that every bit is by Chardin. So it's quite difficult to see actually how the cross-examination of Dickinson would have run if the claimants had been running this point. So that's where we were in the case. And just to clarify, or just to step back for a second, in Weems, the findings were Mr. Dickinson was competent to do the job in hand. His actual non-negligent assessment was consistent with the literature, and the mandate and the duty of care arising from the mandate didn't require Dickinson to give advice on attribution for the purposes of the sale. So let's just play around with it a little bit and see what would be the case if you changed some of these facts a little and to more likely facts. Now, let's just start from a proposition that the central tension in this type of case, and in fact, it's in many, many art cases, is between the vendor's interest and the sense of self-preservation of the auction house or the consignment dealer. So it's clearly in the vendor's interest for the piece to be sold with the best reasonably attainable attribution. I mean, there may be circumstances under which it's a bit close to the wind, but broadly, that's going to be where you are. And it'll certainly often be in the consignment dealer's short-term financial interest to achieve that, because they're going to be working on commission. But against that, the consignment dealer may face claims if they go too far. So if they adopt a ridiculously over-optimistic attribution for a piece, they're going to end up getting, they may end up getting sued, and their reputation may well be damaged. And a similar type of situation arises in the context of an auction house, particularly where the auction house, as is the case of Christie's, gives a warranty in relation to certain types of piece. So that's the core tension that we're dealing with here. And I'm just going to explore that in a little bit of detail. So just imagine a situation where the attributor isn't in fact competent to do the job in hand. So that's the first element of the Thompson test. In those circumstances, can the attributor merely rely on the literature? I wonder. Probably not. Or will it entail taking advice from a recognized expert or someone more senior? I think Luxmore May probably says that's what you have to do, but that's in the context of a sleeper. An interesting point that arises is what type of expert do you have to consult? Now, in the Weems case, this was quite easy because Mr. Rosenberg was acknowledged to be the preeminent expert. And to the extent that, although actually Michel David-Weil's sale didn't suggest that this was correct, but to the extent that he was the person that all collectors in the market would pay attention to. Now, that isn't true of every artist. So dealing with Caravaggio, that's just not true. And in those circumstances, is it negligent for the consignment dealer to go to the best expert, i.e. the Rosenberg, the preeminent expert, or would it be better for the expert would it be better for the dealer to go to the expert who will give you the best answer? And in practice, the way that dealers in fact often do build up the attribution of a piece which they own is by starting off with the small experts and then working up. But is it negligent not to do that? The point wasn't really run with any conviction in Weems, and it may be because Andrew Onslow ran the opposite line of argument in Thwaites against me, so we don't know, but anyway, that's where we are. It's an interesting point to think about. The next point is just imagine there's a mismatch between the attributor's view and the literature. That wasn't the case in Dickinson. And there's two possible scenarios. The first is that the attributor thinks the piece is better than the attribution of the piece in the literature. And in those circumstances, I think it's probably pretty clear that that is a non-fanciful doubt which must be shared with the vendor. And I've compared it with a comment which the judge made, which I'm not going to bother you with here. The alternative scenario is that the attributor thinks the piece is worse than its attribution in the literature. So what do you have to do there? Is it appropriate for the dealer to withdraw from the sale, saying he's not happy? Can he just go on and sell anyway, relying on the literature possibly? It's quite complex, that point. In practice, having stepped back from it a little bit, I think it's probably very unlikely to be litigated, because in doing so, the vendor is going to be trashing his own piece. So it may be that that's not a piece that we ever know what the answer is to. I mean, it could arise in certain sectors, but it must be quite unlikely it's going to. And the third type of situation, which isn't dealt with in Weems, is what if the mandate includes an obligation to advise on attribution? So what if the mandate includes an obligation, and this could arise either as a term of the contract, and probably following Weems, these kind of points are going to be pleaded out, or as part of the contractual duty of care. And in those circumstances, what's the dealer going to have to do? I mean, this was the essence really of their case. What's the dealer going to have to do? Is he going to have to share all of his reasoning, some of his reasoning, some of his market intelligence? And how much advice will the dealer have to give as to how the attribution could be improved? Now, normally in these circumstances, I duck the point by saying it's going to be fact specific. And I'm afraid I'm going to do that again today. It's going to be hugely fact specific. And I think what Weems has told us is that the point is going to depend really substantially on the terms of the mandate. By the way, I should say that we have a mechanism for answering questions or seeing what questions are. So if you do want to ask us some questions, and no offense if you don't, But if you do want to ask some questions, do just send us some, and I think Eliza will be able to, between the two of us, we'll be able to deal with them. The last point in this area in relation to attribution is, does the attributor have a duty to advise that they might be wrong? Now, a lot of time is spent on this, and I have to say, when we first started in this area, dealing with this area, so going back to Aurora, there wasn't much authority on qualifying advice, and we looked for stuff in solicitors. There's very little actually in solicitors, but happily there's been a whole line of tax cases, tax negligence cases, about people promoting tax schemes having to give advice that the revenue might take another view, which is sort of not a terribly striking proposition. Where we are at the moment on that is that there's no general duty for an advisor to advise that they might be wrong, and it's highly fact specific, and that's what Lady Justice Aspelin says in the Barker and Baxendale Walker case. So in our case, in what circumstances will this duty arise? Well, firstly, I think really it comes down to Thompson again. Does the relevant attributor have the right level of competence for the job in hand? I mean, if they don't have the right level of competence, they should probably be saying, you should be thinking about somebody else. Has the attributor done enough that they can feel confident in their view? And that will include having a proper trawl through the literature to check whether there's anyone else that takes a different view about this particular painting. And then thirdly, ought the advisor to have non-fanciful doubts that they may be wrong? And the extent of that duty is going to be mediated by the difficulty of the job, how difficult it is, what the chances of being wrong. So fakes, that's a point that arises up from Eskenazi. And also this third point, which about severity of the effect of being wrong. Now, in all these cases, the point that's always run, it was run in Weems and I've run it in the past, is of course you have to say to a vendor that the painting could be right if you have even the slightest whiff of it, because the difference between a painting that is wrong and a painting which is right is an enormous difference in money. That's the point that's always argued. That point is specifically dealt with by the judge in Weems, and he dismisses it, but he dismisses it on the basis that the downside risk of going to Rosenberg was very substantial. It was a spin of the roulette wheel. Whether it would be dealt with in the same way in other cases is, I'm afraid, going to be, guess what, fact specific. So I don't think this whole Coutson O'Hare, Barker and Baxendale Walker line of authority is actually really going to help us very much in understanding where we are. It's going to be going back to the mandate. Possibly the most important point, and I'm keeping my eye on the clock, possibly the most important point in the case was this point about sale to another dealer. And I understand from what contacts I have in the art world that the art world was really worried about this point. That's because intertrade sales are very common. And as anyone that has ever done an art case will know, it's absolutely not standard practice to inform clients of the identity of the purchaser, even if the purchaser is trade. And that's true of dealers, sale by dealers, it's true of consignment dealers, and critically, it's also important in true of private treaty sales by auction houses. And the other side made quite a lot of this in cross-examination of Mr. Dickinson, but we gave that a good kicking. Anyway, so the Weems's argument had a sort of the virtue of elegant simplicity, which is that if a member of the trade, i.e. Dickinson, was selling to another member of the trade, the other member of the trade must be buying at an undervalue because the trade buyer wanted to make a profit and would have been intending to make a profit. Now, what we said, of course, is that actually ignores the risk entailed in buying any piece of art and trying to sell it at a profit. So our argument was that the trade buyer was the only realistic buyer because only the trade buyer would be willing to pay the fudged price, which was, i.e., the price much bigger than a studio copy price, but rather less as it turned out, quite a lot less than someone was willing to pay for the price on an autograph basis. Held, and this is what the judge held, I cannot find that the sale of the painting to another dealer constitutes any form of negligence unless there is some evidence to indicate that the seller knew or should have known that they could have sold at a higher price directly to that dealer's client and actively decided not to do so. So in practice, what the judge was doing, and I think it's probably right, what the judge was doing was just batting away the clean argument that sale to another member of the trade will always be negligent. Now, there may be some situations where sale to a member of the trade is negligent, but not merely because they're a member of the sale, but not merely because it's a sale to a member of the trade. So that's generally the issues relating to consignment, duties of a consignment dealer. And as I said, I think the take-home points from it are that the mandate and pleading the mandate is going to be very important going forward. And actually, this argument in relation to sale to a trade buyer always being negligent just isn't going to be right. Causation and loss, I'm going to deal with this quite briefly. There are three interesting points here. Firstly, the point which we made permission to appeal hearing, that if Dickinson had acted non-negligently, the Weems would have done exactly the same thing. And that's governed by the reasoning in Bolitho. The Court of Appeal accepted it, and that's why the permission to appeal application was rejected. Andrew Onslow, understandably, I would say, made a concession that this was what was going to happen, so that the Weemses would have trusted Dickinson to give the right advice. So that means all we really had to show was that the advice that Dickinson would have given in the counterfactual was non-negligent. But there's two other rather more technical points here. And to those of you that are not negligence specialists, but my apologies, but I'm just going to try and explain these points at a bit of a lick. So the first point was the failure to consult Rosenberg should not be treated as a loss of a chance for the purposes of causation and assessing damages. And the second point was one relating to the application of the fair win principle. Now, dealing firstly with the loss of a chance point, the first observation is this is obiter, but the issue in play is potentially a very important one, because the question is does a claimant in an art case have to show on the balance of probabilities that an expert would have decided that the piece was right? Is that what the claimant has to do? Or is it instead, because that can often be quite difficult, or is it instead that the claimant merely has to show that there was a chance that if the painting had been shown to the expert would have decided that the piece was right? And just to give you a whistle-stop tour through the law of loss of a chance, which we could spend an hour on, the basic distinction is between these two types of situation. And we're talking about assessment of counterfactuals here. So it's what if. Firstly, in cases where the counterfactual depends on what one of the parties would have done, so in this case, the Weemses or Mr. Dickinson, the claimants must prove what would have happened on the balance of probabilities. But in cases where the counterfactual depends on what a third party would have done, the claimant's loss will be assessed on the basis of the chances that the third party would have acted so as to establish the loss. In other words, that the loss of chance principle would apply. So the distinction is between, if it's one of the parties, you look at balance of probabilities in practice because they're before the court giving evidence. And if it's a third party, most likely one that isn't before the court giving evidence, loss of a chance could be in play. And to give you a classic example, in Allied Maples, the claimant suggested that because of the defendant's negligence, it had lost the opportunity to negotiate better terms in a contract. The damages were assessed at the amount by which the claimant would have been better off had the favourable terms been negotiated, multiplied by the percentage chance that the landlord would have agreed to those, or forgive me, the other party would have agreed to those favourable terms. And you can get into very complicated situations where you have sort of stochastic analyses of different percentages and everything. It gets very complicated very, very quickly. Now, the Weemses case was that Rosenberg's decision was a decision by a third party. And so therefore, the loss of a chance applied for the purposes of the counterfactual. Our case was a little more subtle, which was that it's not really about third-party decisions, it's about verifiability. And we used this case, it's a judgment of Mary Arden called Electrin, which was a very complicated commercial case about valuation of shares under a contract, where Mary Arden held, or sorry, Lady Arden, I should say, forgive me, where Lady Arden held that you could decide that point on the balance of probabilities in the case because the evidence was before her, and that just because there was a third-party expert involved, it wasn't appropriate to invoke loss of a chance. Now, it's had quite a varied history, that case, partly because, as we will say, as we say, these loss of a chance cases come in so many different forms. And for the first time in my life, I actually cited an article, forgive me, Lies and Lies, cited an article, which is this article by Helen Rees called Loss of Chances in the Law, which is sort of quasi-philosophical analysis of the notion of verifiability and the extent to which the process of assessing counterfactuals involves the court making assumptions. It's not a great read, but it was approved by the Supreme Court in a case on damages. So what we said was whether or not Rosenberg would in fact found the painting was fully autographed was in this case verifiable. And so you shouldn't be, we said, oh judge, you shouldn't be engaging the loss of a chance principle. The court held this, that the loss of a chance didn't apply because the question of what Rosenberg would have decided was analogous to the valuation of shares in Electrin. Now, so he accepted our argument. But the important point is he accepted on the basis of our analysis that it was verifiability that was the issue in play. And I should say as a sub point that there clearly are cases in which loss of a chance applies. And a classic example would be burning cases, which we can discuss if you ever want to. So points to note from the judgment. Firstly, the judgment's obiter, but it is the only case in our case where this point has been decided. Secondly, he accepted that the question of whether something is suitable for loss of a chance is dependent on verifiability rather than dependent on this formalistic distinction between whether there's a party involved or a third party involved in the assessment of the counterfactual. And what that means is that the answer may be specific to the evidence before the court. So again, this is going to be fact specific, and it may depend on how much evidence you have in relation to the expert. In this case, we had a lot of evidence in relation to the expert. But the critical point is, and this also deals with the fair win point, the critical point is that the judge's answer on the loss of a chance point is made in the context of his assumption as to the counterfactual. And as I say in this note, he made on the assumption that the painting is clearly at least as good as the two Louvre pictures. And therefore, he is assuming in practice the outcome of Rosenberg's assessment. And so that must mean, surely, that Rosenberg's decision is inherently verifiable because he's assuming this conclusion. And we can see that from the next paragraph after he deals with loss of a chance. He says this, I come back to the fact that we only get to the issues of causation and quantification at all if we assume that Mr. Dickinson was negligent in selling the painting on the basis of an assessment that is partially Chardin and partially Estudio. If that assessment was negligent, then we must assume that any competent Chardin professional viewing the painting would have concluded that it was in fact early Chardin. And we must therefore proceed on the basis that Monsieur Rosenberg, being a supremely competent market professional as regards Chardin, must be assumed in this context to have come to the same conclusion. So in other words, the assumption that the judge is making on this whole counterfactual analysis about causation and loss is that Rosenberg would have found that the painting was wholly by Chardin. And in those circumstances, you get two conclusions from that. Firstly, it's never going to be a loss of a chance case. So that means that in other cases, it may be possible, I would have guessed, to argue that loss of a chance is available in our cases. And secondly, in the context of fair wind, which I'm going to deal with next, in the context of fair wind, it really doesn't mean much. And I'm just dealing with this very quickly because I'm conscious that we're now 1 minute over the time. In the judgment, the judge applied the fair wind principle to find that Rosenberg would have found the painting to be fully autographed. Now, the fair wind principle will normally only apply, this is point B, if the defendant has wrongfully made it difficult to prove the proposition in question. And the classic case is the case of the driver of a steamship who went deaf because of the noise of the engines. And there was an obligation on the steamship company to keep records of how noisy the engines were. So therefore held, this is effectively going to be assumed against the defendants. And so that's how the principle works. But if they're, of course, in this case, I'm going back to this, forgive me, how we go? Who lost it? There it is. Forgive me. In this case, going back to the judge's statement that Rosenberg must be assumed to have found that the painting was held by Chardin, you don't need this point because he was already assuming that the painting was clearly as good as the two Louvre pictures. However, it does raise the facts of the Weems case do raise a really interesting point for claimants in future cases, which is what do you do if you've got a transparency of the picture, which is likely to come up in the course of disclosure? What do you do if you've got a transparency of the picture and you can send it to the expert? Do you do that? It's a risk because, of course, if the expert says it's not right, then that's going to be the end of your case. But equally, if you don't do it, maybe you're losing the opportunity to run the point on fair wind. Anyway, that's an awful lot to get through. We've given you some pretty pictures and hopefully some food for thought. Have we got any questions?
I don't think we do.
Oh yes, hello Lizette, how are you? Lizette's question is, if there is a recognized expert on an artist, then dealers, auction experts would be expected to consult that expert and consult them first, regardless of their own competence. Their own competence surely only comes into play if there is in fact no recognized expert. Well, I mean, it's actually a statement that rather than a question. I'm not completely sure I agree with it. I think it probably depends on what the job is in hand. And clearly, auction houses don't always consult the recognized expert on an artist. That they do if they have the opportunity to, but whether they're negligent to, whether they're negligent not to, will be another matter. In the context of a dealer, obviously the dealer is going to, well, put it this way, the dealer is going to be able to get a better price for the picture if he has the affirmation of the recognized expert in the artist. So insofar as that was a question, Lizette, I think I've answered it. If it wasn't a question, I think I kind of disagree with it. I think that's it, isn't it?
Yes, that's the only one.
Well, thank you very much. We can't hear people applauding, maybe you're not. And I think at this stage, we will just press the leave button. Is that what we do?
It's been a long time since we've done this. Yes, leave, there we go.